Penalty Charge Notice, PCN, and bailiffs. In almost every case the local authority will send bailiffs to your home, to recover unpaid penalty charge notices. The local authority will apply to the Traffic Enforcement Center, also known as the Northampton County Court Business Center, for a order for recovery. The order for recovery is a rubber-stamped document only. There are no district judges, magistrates or clerks at the Northampton County Court Business Center, as these premises are for admin staff only. None of these staff are legally trained either. You will be sent the order for recovery. It is also worth to note, this is not a county court judgment, CCJ, due to the fact that this document was processed by admin staff. At this point you have two options: pay the amount due including the admin fee, or make a statutory declaration within 21 days from the date of the order for recovery. If neither of these are done within the 21-day time limit, the local authority will apply to the Northampton County Court Business Center for a warrant of control. Please note this is another rubber-stamped document produced by the admin staff. The local authority will then pass the warrant of control onto one of their contracted private bailiff companies they use to collect these debts. Then this becomes the first steps in the enforcement process. Before I go any further, please note, if the warrant of control is in the name of a business or the named debtor is operating out of business premises, then this will not apply to you, as bailiffs and enforcement officers have more powers when collecting civil debt on business premises. Or, if you own a vehicle and it's free of finance, if the pursuing bailiff finds it, he or she will clamp it and hold it to ransom. If you don't pay them, they will remove your vehicle and it will be sold at auction, with the money going towards the outstanding debt and bailiff fees. If you have taken out a personal loan to buy a vehicle, the bailiffs will clamp it to take control of the vehicle even if payments are still being made to the finance company. This is because most personal loans are unsecured. There is an exemption to this, the Tribunals, Courts and Enforcement Act 2007. Taking Control of Goods 2013, Section 4 Exempt Goods, Paragraph D, a vehicle on which a valid disabled person's badge is displayed because it is used for, or in relation to which there is reasonable grounds that it is used for, the carriage of a disabled person. It is also worth to remember, Schedule 12, of the Tribunals, Courts and Enforcement Act 2007, Paragraph 10, an enforcement agent may take control of goods only if they are the goods of the debtor. If your vehicle is on lease or is still under third-party ownership due to a contractual finance agreement attached to a hire purchase vehicle, then the bailiff cannot take control of the vehicle. This means they cannot clamp it or remove it. Powers. You will receive a number of letters, with the first being a notice of enforcement. This allows the debtor 7 days notice before a bailiff can visit you on your premises. You will receive many more letters typed in big red fonts with threats of removal of property, court action taken against you, 24-hour removal and final notices that are all designed to intimidate you into paying them. In 9 out of 10 situations the bailiffs will tell you that the warrant of control gives them the right under the legislation to enter your premises and remove your goods if you don't pay them. This is factually incorrect. They do not have unrestricted entry to any premises, let alone residential premises. A power to enter premises by force exists only for the execution of high court and county court debts. At business premises or at any premises where an enforcement agent is enforcing criminal penalties. A power to re-enter premises by force applies both to residential and business premises where a controlled goods agreement is in place and the goods remain on the premises, and the debtor has failed to comply with the repayment terms or is in breach of any part of the agreement. So, any bailiff, whether a county court bailiff or a high court enforcement officer, has limited power of entry when collecting civil debt on residential premises. If the police turn up, they cannot assist a bailiff with a civil matter. Their job is only to prevent a breach of the peace, so stay calm. You don't have to engage with the police if no crime has taken place. Do not let the police into your home either, as the bailiff will follow in behind. Private bailiffs appointed by the local authority collecting unpaid PCNs have very limited powers of entry to residential premises. Due to the fact they are not court bailiffs, and this is a registered civil debt with a non-court, the Traffic Enforcement Center, also known as the Northampton County Court Business Center, is not a court, it is an admin center. What this means is, if there is no vehicle to take control of, and you are refusing to pay them any money, the only option left to the bailiff is to take control of goods from inside your home. But for the bailiff to do this, they would need to enter your residential premises, and there lays the problem for the bailiff. The bailiff has no power to force entry on residential premises for civil debt unless they have previously made peaceful entry and the debtor has breached a signed control of goods agreement. The only way the bailiff can enter residential premises is with a warrant of control when collecting a civil debt, under Schedule 12 of the Tribunals, Courts and Enforcement Act 2007. Section 14. Entry without warrant, Paragraph 1. An enforcement agent may enter relevant premises to search for and take control of goods. What this means is a registered and certificate bailiff under the lawful authority the court, under Schedule 12 of the Tribunals, Courts and Enforcement Act 2007. Section 14 can present themselves at the debtor's premises with the warrant of control, and only enter by usual means by which entry is gained to the premises to search for and take control of goods. There are only two ways the bailiff can achieve this. They walk through an unattended, unlocked or open door, or you invite the bailiff into the premises. They can only make peaceful entry by normal means only. What this means is the usual way you can enter the premises. In most instances on residential property this would be via the unlocked front or back door, or garage only. They cannot climb through open windows or over walls. The most important thing you need to know at this point is, under no circumstances, never let any bailiff into your home. If you let them in or they walk through an unlocked door, they would have made peaceful entry. The bailiff will take legal ownership of goods on the premises under a control of goods agreement with the debtor to secure against the debt. So, it is very important you understand that, if you're expecting bailiffs to visit your home, keep your doors locked at all times and never invite them in. Under the current legislation, a debtor is under no legal obligation to assist a bailiff. There is also no requirement for you to identify yourself to a bailiff. You cannot be arrested for not complying with a bailiff requests to enter your premises. If you refuse or peacefully prevent a bailiff from making peaceful entry and they are threatening to make an application to the court to force entry with a locksmith, they are just trying to get you scared so you will comply to their requests. Currently there are no prescribed court procedures for a bailiff to have an audience at a magistrate's court to make the application. Due to the fact magistrates' courts don't deal with civil debt and only the magistrate court, under Schedule 12 of the Tribunals, Courts and Enforcement Act 2007, Rule 10C of the Criminal Procedure Amendment Rules 2015 for criminal penalties or unpaid HRMC taxes can issue a force entry warrant. The county court would need proof that the bailiff has previously made peaceful entry and there is a valid signed control of goods agreement in place to which the debtor is in breach of and has continually refused or prevented the bailiff from entry to remove the goods for Schedule 12 of the Tribunals, Courts and Enforcement Act 2007, Section 15 to be considered by the court. There are many videos on the internet of bailiffs and enforcement officers misrepresenting their powers to intimidate people, to forcibly get them to comply with their requests. When dealing with bailiffs face to face, make sure you do it through an open window, or, if you're on your doorstep, make sure you close and lock the door behind you. Also video the encounter on your smartphone to ensure against any procedural improprieties on the part of the bailiffs or enforcement officer. The bailiff has a 12 months time limit from the date on the notice of enforcement was issued to collect the debt. If they are unable to do so, the case is returned back to the original creditor. In this instance it's the local authority. So, Remember, the only time a court bailiff or enforcement officer can apply for a warrant to force entry with a locksmith is under Schedule 12 of the Tribunals, Courts and Enforcement Act 2007. Rule 10C of the Criminal Procedure Amendment Rules 2015 for criminal penalties or unpaid HRMC taxes. Or under Schedule 12 of the Tribunals, Courts and Enforcement Act 2007, Section 15 and 16. Where the bailiff has taken legal ownership over your property to secure against the debt and the goods are on the premises. That the debtor has breached a signed control of goods agreement and the bailiff has been prevented entry to the premises to remove the goods after the breach. This is because the property that the bailiff has taken legal ownership of, no longer under this legislation belongs to the debtor. If the bailiff is being refused or prevented from entry to the premises to remove the goods, then arguably this is no longer a civil matter.